Greetings of peace from HRM Business Solutions Incorporated, HR Team Asia, and Careers Unlimited. This is our second episode, the second module in a series of HR conversations. And our topic today is to explain the latest Supreme Court decisions on human resources, on ER and employee termination. You know, ladies and gentlemen, as a professor of law and as a bar reviewer in many universities in Manila and even in the Visayas and Mindanao, I have always made it a habit to review all the decisions of the Supreme Court. And today I have 5 very interesting cases to be discussed. The first case is about Asian Institute of Management. Do you know this is a very famous institution where executives from the ASEAN region, from Singapore to Thailand to Vietnam, Cambodia, Laos, Brunei, and Malaysia, studying in, even from Japan and India and Pakistan, they are studying in EIM. But you know what happened? The faculty members of EIM formed a union. And the question now is that the management of EIM considers these faculty members as managerial employees. So the lawyers of management filed a case to cancel the certificate of registration of the union on the ground that they are not authorized by law to form a union. Only rank and file and supervisors can form a union, separately, of course. But management said, no, in EIM, faculty members are empowered. They recommend policy. In fact, they formulate policy. And so there was a legal battle in the regional office of the Department of Labor. And the ruling of the regional office is that, yes, management is correct that you cannot form a union because you are managerial. But of course, the faculty said, how come the faculty members in Ateneo, in LaSalle, and even in UP are considered rank and file? And they are performing the same function. And so the union of EIM filed an appeal to the office of the secretary. The secretary of labor reversed the decision of the regional director and said that, no, the faculty members are not managerial. They are rank and file. Therefore, they can form a union. And so, from the Secretary of Labor, they went to the Court of Appeals. And the Court of Appeals decided that indeed the Secretary of Labor is correct when it comes to determination who are qualified to join union or not. The justices of Court of Appeals would respect the decision of the DOLE because they are the expert on this matter. This is a very important case. This will affect all the human resources in all universities all over the Philippines. And the question now is the management of EIM correct in considering their faculty members as managerial? Because this has never happened. Since 1974, when the labor code was promulgated, and even before, if you remember, my colleagues in HR Team Asia, who are much older than me, like Mr. Ed Torres, for instance, no, would remember, because these people were already around before the labor code, that in 1953, there was a law known as the Industrial Peace Act, Republic Act 875. And under that law, even supervisors were allowed to join unions. But when President Marcos promulgated the labor code in 1974, he stopped the unions of supervisors. He said that supervisors are part of management. From 1974 onward, supervisors were managerial. Managers not allowed to join unions. But in 1989, a senator from Cebu by the name of Ernesto Boy Herrera amended the labor code together with a congressman from Leyte, Alberto Veloso. They came up with Republic Act 6715, and they revived the unions of supervisors in March 21 of 1989 after the new Constitution of 1986. And so the law, ladies and gentlemen, today is that managers are not allowed to join unions. Supervisors are allowed, but they must be separate from the rank and file. Now, the question in AIM is this. If the faculty members are not rank and file because their recommend policy is recommendation not considered as a supervisory function. And so as such, would the faculty members not be qualified to join unions as supervisor? I do not want to preempt the ruling on this, but I'm giving my opinion with all due respect that I believe that faculty member may have the right to join, assist, and form unions of their own. So that is the first case. We go to the second case. The second case is a very important case for HR manager. This is the case of Chateau Royal. Chateau Royal Sports and Country Club. You know, this case was decided by the Supreme Court on January 18, 2017. Take note, ladies and gentlemen, the cases I am discussing here are very new cases. January 18, 2017, decided by the Supreme Court through the writing of a very learned professor of law, Justice Lucas Bersamin, and he is a bar top-notcher. And the question is this, very simple. The prerogative of management to transfer employees. If you are an employee assigned in Nasugbo, Batangas, and you receive a memo from management transferring you to Manila, you are removed from your family. No decrease in salary, but you will have to spend more money because you have to rent, you have to, adjust to a new situation. Now, the employees here disobeyed the order. They do not want to transfer because that transfer will mean diminution in their take-home pay because of additional expenses. But management insists, this is our prerogative. And remember that under Article 282 of the Labor Code, which is now renumbered as Article 297 by virtue of Republic Act 10151, insubordination. How do you define insubordination? Insubordination is defined as willful disobedience to a lawful order given by a superior in relation to his work. Now, the order to transfer from Nasugbo, Batangas to Manila was a lawful order. It was in relation to his work. And therefore, to violate that order willfully would constitute insubordination, which justifies the dismissal. And so this case, therefore, was decided by the Supreme Court in favor of management. And this is a very important case. Employees, remember, you cannot just refuse transferring. My advice to you is this: follow the order and then ask for reconsideration. Never, never defy, disobey the order of your management on the ground of constructive dismissal. This is not constructive dismissal. According to the Supreme Court, this is a valid exercise of management prerogative. Very good case. Then the next case, the third one, is grant placement. Yeah, remember, for all the OFWs who are listening to me, this is very important case. You know why? In this case, decided by Justice Mariano del Castillo, on January 18 again, 2017, barely less than 1 month ago. That is my research. And the issue here is about contract substitution. Here is an OFW that was recruited in Manila, promised a high salary. When they reached the Middle East, they were compelled to sign a new contract with lower salaries and benefits. And you know, when you are a Filipino, you have paid a lot of money to the recruiter, and you are placed in a country where you have no control. The only way to survive is to sign. Now, under the new contract, there were a lot of very, very unfair provisions. But the employee just followed. And after the expiration of the contract, he came back to the Philippines and filed the case. Now, the first issue is this: which law will apply? Is it the law of the Philippines or the law of Dubai? Considering that the employment is in Dubai, the Filipinos was hired in the contract signed in POAE was changed with another contract. The first issue, this is very important case. Why? The Supreme Court said, let us use the word, the principle of lex loci contractus. Lex meaning law, loci is location, contractus is contract. Where was the contract signed? The only contract that the Supreme Court recognized was the contract that was signed in the POAE. And since the POAE is in the Philippines, the law of the Philippines will apply because it is the law of the country where the contract is signed that will apply, not the place of work. Okay? That is a ruling in favor of the worker. Now, since the contract that is recognized by the Philippines is the first contract, that second contract does not exist. It was null and void from the very beginning. It was contrary to public policy. Therefore, all the conditions imposed unilaterally were considered not written. And since the employee was illegally dismissed, the rule now is this: when you have a 2-year contract, that is 24 months, and you are dismissed on the 12th month, your salary for the entire unexpired portion should be paid. And who will pay? It is not the employer in Dubai, because the Philippine courts do not have jurisdiction over these people in Dubai. It is the recruitment agency here. That is why we are required to avail of the services of this recruiter, because when we have problem, we can... cannot summon the employer in a faraway country. They have precisely appointed an agent here. And the agent will answer for all the liabilities of the principal. Let him collect from the principal later. But our courts will control them. The POAA will cancel their license. I have a lot of cases on this. So, you recruiter, you OFW, you have to be forewarned. And this is a very important case. Contract substitution is a ground to cancel the certificate of registration of the recruiter here because that is considered as an illegal recruitment act. When you substitute, then the recruiter would say, we have no control about what they will do there. Well, precisely, you have no control, but the law holds you responsible for whatever action, illegal or legal, that has been done abroad. Thank you. So we go to the next case. The next case is about disability claim of seafarers. Do you know that we have more than 500,000 Filipinos manning the ocean-going vessels all over the world? Do you know that the Philippines is the #1 suppliers of seafarers? And here is a seafarer by the name of Joselito Marcos. This is decided by the Supreme Court again on January 18, 2017. This day is a very productive day for the Supreme Court. They released all their decision on January 18, 2017. And take note, the author of the decision is the Chief Justice herself, Maria Lourdes Sereno. This lady is a very prolific professor of law in UP. He has never become a judge or a justice, but she was a professor of law. And this case is about a Filipino, a simple, able-bodied seaman, the lowest ranking employee in the vessel. He is doing the cleaning of the machines, and he is the servant of all the officers of the vessel. And one day while he was working, his left eye was hit by a screw. And because of that, he was diagnosed to lose 30% of his vision. And so when he came back, he filed a case. It was denied, and then he appealed until the Supreme Court awarded him permanent partial disability. It is not, if it is a permanent total disability, it would amount to $90,000. But if it is only partial, the POAA has a standard employment contract with a list of liability grading. Grade 1, that is total, until you reach grade 12. It is a grading. The bigger the number, the lower will be the award. But ladies and gentlemen, many of our seafarers are covered by collective bargaining agreement. Do you know that there is a union, a big union of Filipino officers and seafarers having a collective bargaining agreement with all the ocean-going vessels. And when you come aboard and be hired, the moment you step aboard until you are disembarked, you are covered by insurance. And the insurance is up to the amount of $90,000. And when you die, your wife and your children, for every minor child, will also receive benefits. So, compared to the land-based Filipino OFWs, the seafarers are better off. But the problem with them, they have shorter contract. Some of them 6 months only, or even 4 months. But the salary is very high compared to the land-based. no? So the next one, the next case that I will discuss is about a food company. This case was decided by Justice Del Castillo on January 15, 2017. This is about illegal dismissal. This is about failure to follow the due process in termination of employment. You know, ladies and gentlemen, I am sad as an HR professional for a long time that many of our HR people today do not follow simple due process requirements. Therefore, out of ignorance or lack of familiarity, they put the company in a very precarious situation of having to pay millions in terms of back wages and separation pay. That's why I call upon you to come to HR Team Asia and HR Business Management, HRM, Business Solutions Incorporated, and Careers Unlimited, so that we can help you. The more veteran people will help the younger generation so that we can leverage our profession, the HR profession, and become a creator of value that will empower the organization and make sure that our decisions are defensible in court. The last case, I think that is the last one already. And so, ladies, to summarize everything, today I have discussed to you a case about the union. That is the EIM case. Then I discussed to you about the OFW. And then I discussed the seafarer. And of course, the due process involving food chain. So, in all this, to integrate everything, the Supreme Court is the last bastion of protection to labor. But protection to labor does not mean that we will take advantage of capital. Because the moment the employers, the investors would see that our labor laws in the Philippines are not fair, in an ASEAN integration context, in a global economy, many of the investment can transfer to another locations. So we have to make our laws very fair. The HR people should assist the top management, become a strategic partner, and really make solutions that are fair to our people. We will not take advantage of our people. We will not commit injustice. We should not allow the HR to be an instrument of injustice. But neither should we shirk from our duties to exercise, for instance, the prerogative to transfer, management prerogative to hire, to discipline, to lay down policy, transfer, promote, rewards, and others. We have to exercise with a great excellence in execution. And so, ladies and gentlemen, I ask you to look forward to the next episode where we will discuss about labor standards and labor relations. This is just a continuation, and I promise you again that our team, our group of experts in HRM Business Solutions Incorporated, HR Team Asia and Careers Unlimited, will be a partner of all HR professionals in creating value-adding solutions that will empower people and organizations. And so, my own contribution is really about law, about labor law. As a former Undersecretary of the Department of Labor, As a former labor arbiter myself and a labor attaché, I can bring in a lot of things to the table and help our organization become a meaningful catalyst of change and builder of capabilities in a fast-changing economy, global arena. And the opportunities are exciting and the chances are tremendous for all of us to survive and to succeed and to help each other. Thank you. This is Attorney Josepos B. Jimenez, JBJ, thanking you and looking forward to having another conversation with you in behalf of our organization. It's our Business Solutions Incorporated. Our President, Mr. Torres, our President of HR Team Asia, Mr. Willie Espiritu, and our Chairman, Mr. Freddy Marquez. Thank you and good day.